And another part of nature of the federal system of our constitution. Now we are talking about the next part of the nature of the federal system. The interplay of the foregoing two forces has been acknowledged even by the Supreme Court in interpreting various provisions of the Constitution, as for example in explaining the significance of Article 301, Article 30. Thus, the evolution of the federal structure or a quasi-federal structure necessarily involved in the context of the conditions then prevailing a distribution of powers, and a basic part of our constitution relates to that distribution with the three legislative lists of the 7th schedule. The constitution itself says by Article 1 that the India is a union of states, and in interpreting the constitution one must keep in the view of the essential structure of a federal or quasi-federal constitution, namely that the units of the union have also certain powers as has the union itself. In evolving an integrated policy on this subject, our constitution makers seem to have kept in mind three main considerations. First, in the larger interest of the India, there must be a free flow of trade, commerce and intercourse, both interstate and intra-state. Second, the regional interests must not be ignored altogether. And third, there must be a power of intervention by the Union in case of crisis to deal with particular problems that may arise in any part of India. Therefore, in interpreting the relevant articles in Part 13, we must have regard to the general scheme of the Constitution of India, with a special reference to Part 3, Part 12, and their interrelation to the Part 13 in the context of a federal or quasi-federal constitution, in which the states have certain powers, including the powers to raise revenues for their purposes by taxation. At the same time, there is no denying the fact that the states have occasionally smarted against central dominion over the states in their exclusive sphere, even in normal times, through the Planning Commission, which itself was not recognized by the construction, like the Finance Commission, the Public Service Commission, or the like. But this is not because the Constitution is not federal in its structure, or that its provisions envisage unitary control. The defect is political, namely that it is the same party which dominates both the union and state governments, and that naturally complaints of discrimination and interference with state autonomy are more common in those states which happens to be for the time being under the rule of a party different from that of the union government. The remedy, however, lies through the ballot box. It is through political forces again that the union government may be prevented from so exercising its constitutional powers as to assume an unhealthy paternalism. But that is beyond the ken of the present work. The remedy for a too frequent use of the power to impose president's rule in the state under Article 356 is also political. The strong central bias has, however, been a boon to keep India together when we find the separatist forces of communalism, linguism, and scramble for power playing havoc, notwithstanding all the devices of central control. Even after 5 decades of the working of the Constitution, it also shows that the states are not really functioning as agents of the union government or under the directions of the latter. For then, events like those in Assam over the language problem or territorial dispute between Karnataka and Maharashtra could not have taken place at all. That the federal system has not withered away owing to the increasing impact of central bias would be evidenced by a number of circumstances which cannot be overlooked. See further chapter 33 post. The most conclusive evidence of the survival of the federal system in India is the coexistence of the government of the parties in the states that different from that of center. Of course, the reference of the Kerala Education Bill by President for the advisory opinion of the Supreme Court instead of giving his assent to the bill in the usual course has been criticized in Kerala as an undue interference with the constitutional rights of the state. But thanks to the wisdom and impartiality of the Supreme Court, the opinion delivered by the court was prompted by a purely legalistic outlook free from any political consideration, so that the federal system may reasonably be expected to remain unimpaired notwithstanding changes in the party situation, so long as the Supreme Court discharges its duties as a guardian of the Constitution. The federalism is not dead in India is also evidenced by the fact that new regions are constantly demanding statehood, and that already the Union had to yield a much demand in the cases of Meghalaya, Nagaland, Manipur, Tripura, Mizoram, Arunachal Pradesh, Goa, Chhattisgarh, Uttaranchal and Jharkhand. Another evidence is the strong agitation for greater financial power for the states. The case for greater autonomy for the states in all respects was first launched by Tamil Nadu as a lone crusader, but in October 1983 it was joined by the states ruled by non-Congress parties, forming an opposition conclave. Though all the parties were not prepared to go to the same extent, the enlargement of state powers at the cost of the Union in the political sphere is not, however, shared by other states on the ground that a weaker Union will be a danger to external security and even internal cohesion in present-day circumstances. But there is consensus among the states in general that they should have larger financial powers than those conferred by the existing constitution if they are to efficiently discharge their development programs within the state's sphere. Under list 2 of the 7th schedule, the Morarji Desai government 1977 sought to pacify the states by conceding substantial grants by way of plan assistance by what has been called the Desai Award. It is doubtful, however, whether the agitation for larger constitutional powers in respect of finance will be set at rest by such ad hoc palliatives. It is interesting to note that the suggestion in the previous edition of this book that the remedy perhaps lay in setting up a commission for the revision of the Constitution, so that the question of finance may be taken up along with the responsibilities of the Union and the states on a more comprehensive perspective, has borne fruit in the appointment in March 1983 of a one-man commission headed by an ex-Supreme Court judge, Sarkaria Justice, empowered to recommend changes in the center-state relations in view of the various developments which have taken place since the commencement of the Constitution. The commission submitted its report in 1988. The Supreme Court referred to the report in S.R. Bommai. The proper assessment of the federal scheme introduced by our Constitution is that it introduces a system which is to normally work as a federal system, but there are provisions for converting it into a unitary or quasi-federal system under specified exceptional circumstances. But the exceptions cannot be held to have overshadowed the basic and normal structure. The exceptions are no doubt unique and numerous, but in cases where the exceptions are not attached, federal provisions are to be applied without being influenced by the existence of the exceptions. Thus, it will not be possible either for the union or a state to assume powers which are assigned by the Constitution to the other government unless such assumption is sanctioned by some provisions of the Constitution itself. Nor would such assumption or encroachment be violated by consent of the other party, for the Constitution itself provides the cases in which this is permissible by consent. Hence, apart from these exceptional cases, the Constitution would not permit any of the units of the Federation to subvert the federal structure set up by the Constitution, even by consent, nor would this be possible by delegation of powers by one legislature in favor of another. In fine, it may be reiterated that Constitution of India is neither purely federal nor purely unitary, but is a combination of both. It is a union or composite state of novel type. It enshrines the principle that in spite of federalism, the national interests ought to be paramount. This is all about today's nature of federal system of our Constitution, and it was the last part of nature of the federal system of our Constitution. Thanks, regards.